Welcome, I'm Jon Caldara, president of the Independence Institute and your devil's advocate. Later on, we're going to talk a little science fiction. I'm looking forward to that. But first, Obamacare is finally unconstitutional, so says at least one judge. I need to learn more about that, so who am I going to ask but Rob Natelson, constitutional scholar. Good to see you.
Great to be back with you, John.
All right, let me just set the stage up, because I was shocked when the John Roberts court originally ruled that Obamacare was constitutional. And if I recall right, it all swung on their power to tax. And I remember Obama at the time saying, this is not a tax. This is not, you'll be forced to buy this product, but it's not a tax. It is the wasn't the Commerce Clause that says we can force you to buy something. Tell me if I'm wrong. The Supreme Court said, no, you can't force people to buy anything, but you can tax them. And on that, John Roberts was a swing vote, and now we have this awful thing.
Yeah, there actually were about 4 different challenges to Obamacare, and the entire statute was never thoroughly challenged. But John Roberts' controversial decision was that if you did not buy insurance in accordance with what's called the individual mandate, you had to pay a penalty. And Roberts determined that that penalty, or rather 4 justices of the court, determined that penalty to be a tax, and therefore the purchase of insurance was a condition upon the tax.
So John Roberts, again, was still is Chief Justice. He joined 5 or 4 liberals. It stood, and the idea again is, if I can charge you a penalty, I can do that under the taxation power that Congress has, and therefore it's constitutional.
Yeah, he said that the penalty would produce some revenue. That's evidence of tax. That the revenue would go to the government. That it was handled on the tax form, and so he decided that this was close enough to a duck to classify it as a duck. John, he was wrong as a matter of constitutional definition, but the Supreme Court decided it was a tax, and therefore the mandate.
Help me speculate on this, and this is purely speculation. John Roberts is known as a social creature of D.C., unlike Justice Clarence Thomas,
right,
who, when he's not on the bench, he's in an RV running around the country with his wife. I mean, he's an American, and that my sense was John Roberts felt a lot of pressure from the cocktail circuit, if you will, of D.C. and that realm. I think that's what pushed him over. No one will really tell.
No, nobody really knows, and there's another aspect to this case that very few people discuss. Nobody took the tax issue seriously. People assumed that the constitutionality of the mandate was going to be determined under the Commerce Clause and the Necessary and Proper Clause, and neither side really briefed it adequately. I believe that had full briefs, full information been provided to the court as to what a tax is or isn't under the Constitution, that Chief Justice Roberts may have felt no choice but to go the other way. But that's simply rewriting history. It's 20/20 hindsight.
All right, so let's keep going chronologically. Then Republicans take control of Congress and remove that penalty,
yes,
from Obamacare. So right now, while the law says I must buy this health insurance, and I still have to, there's no penalty if I don't. So it is a toothless law at this point. Whereas before, I could have been penalized. Hell, I could have gone to jail at some point if I didn't pay my taxes over it. So this now, I'm free to break the law without consequence.
There are 2 parts of this latest decision, which comes out of a Texas U.S. District Court. One is the holding that the mandate, the order, is no longer constitutional because, as you just say,
right, I just want to make
there's
sure
no longer the penalty behind it.
Right. So,
right.
As on the timeline, Obamacare, constitutional, taxes, we pull away the penalty, and then this is really what I want to get down to: is this case in Texas? I don't understand it.
Okay. So there are 2 parts here. The judge comes out and he says, based on what the Supreme Court has said, the penalty's gone, there's no longer any constitutional backup for the mandate, and so the mandate's gone. That seems to me to be unassailable. I don't know how you argue that the other way. The more controversial part of the decision is that he also says that since the mandate is gone, the entire rest of the law is gone. all the taxes like the hospital equipment tax, the medical equipment tax, all of the regulations imposed on physicians, imposed on hospitals, imposed on insurance companies, they're all gone. And his reasoning is, his name is Judge Reed O'Connor, his reasoning is that the mandate is such an integral part of the rest of the law that the rest of the law can't survive without the mandate.
So from his point of view, the mandate is the engine of the car. Without the engine of the car, it's not moving, so you can't have all the rest. It doesn't make sense.
That's right. The mandate increases the market for insurance companies and hospitals. They can sell more insurance policies, and they can sell more health care because people are forced to buy health insurance.
Let me repeat that back to you, make sure I'm following you.
Yeah.
So the mandate was put into Obamacare because the idea was you're going to give coverage to everybody, and you're going to have no limits on coverage, and you're going to have no pre-existing conditions, so everybody can get insurance. There's no limit on how much in services. So obviously the costs are going to go skyrocketing for insurance. We, the government, are going to mitigate that by forcing healthy people to buy insurance, which will subsidize all the expensive part of Obamacare. Now that mandate is gone, that there is nothing to force healthy people to buy insurance, we can't pay for those people who need the services.
Yeah,
is that the idea?
The idea, the whole thing is like a big wheel, okay? We force people to buy insurance. That means the hospitals can sell more health care. It means more that insurance companies can sell more insurance, okay? That then gives them the revenue they need to pay for the regulations imposed upon them and for the taxes that they have to now pay that are imposed by Obamacare.
On hospitals.
On hospitals, on providers. Right. The tax revenue then goes to the government. The government then uses that tax revenue to support people, subsidize people through tax credits, for example, so that they can comply with the mandate. In addition, the regulations that the insurance companies and others have to comply with, that is supposedly makes healthcare more affordable. Remember, the name of this thing is the Affordable Care Act. That enables people to purchase insurance. So it's all like a big wheel. Some would say a big creaky wheel. and the mandate is integral to making this work. Now, you see this in the law itself, and one of the things that Judge O'Connor pointed out is that over and over in the law, you get language like this. The mandate is an essential part of this larger regulation of economic activity, and the absence of the requirement would undercut federal regulation of the health insurance market. So at least 6 times in the law, the centrality of the mandate to making the whole thing work is emphasized.
So were you reading from his decision, or
no? I was reading from the law,
from
an actual section of the law, right?
The ACA.
So there's no speculation about this. This is repeated again and again in the law. So then the question becomes that the judge has to answer is, would Congress have passed this law without the mandate? And he says no. The law itself says essentially not, and therefore the entire law collapses. That's his analysis.
How sound is this from your opinion? I mean, if the funding source for all this engine work, all those wheels to spend, is forcing people to buy insurance when they don't want to or they don't need, in their opinion, don't need it, to subsidize everything else, this wheel stops spinning. It seems pretty logical to me, but I've got to be honest.
Yeah.
I don't want this thing to stand, so my viewpoint is colored.
Again, I think the argument that that such things as community rating, requirements that nobody be denied as a result of pre-existing conditions, I think they're so tied in with the mandate, I don't see how they can survive without the mandate. There is a respectable argument, though, John, that other parts of the law that have to do with, for example, regulations on physicians, reporting requirements, the taxes, that they can be severed out from the mandate. I think that Judge O'Connor makes a very good argument that they cannot be severed, but I think there's a respectable argument on the other side as well.
Why didn't he issue an injunction against it? If he ruled that it's unconstitutional, why didn't he do what judges do? Say, it's unconstitutional, stop doing it?
The states that challenged Obamacare asked them to do that. Traditionally, John, there's a reluctance to issue injunctions against the government. You want to assume that the government is going to honor the court's decision. There's also a reluctance to issue national injunctions. We have seen in recent months the phenomenon of judges issuing national injunctions against the Trump administration on such issues as the travel ban. That is not traditionally the way judges work. I think
so I'm seeing a double standard here. When it's stopping Trump, then they'll issue a bunch of national injunctions. Stop doing this wholeheartedly. When it's Obamacare, they step back and say, we will defer and we'll let this work through the process.
I think that's exactly what's going on here, is a double standard. The traditional approach in either case would be not to issue an injunction and allow the case to percolate up through the courts.
All right, what happens next? So I want an end to this. How guaranteed is this to go to the Supreme Court?
I think there's a pretty high probability it's going to go to the Supreme Court, but first it's going to go to the U.S. Court of Appeals, and they're going to deal with the issue of whether the mandate is still constitutional, and if it's unconstitutional, whether the rest of the law survives. From there may be a request for what's called an en banc hearing, where every judge of that particular Court of Appeals gets to hear the case, and only then is it likely that the Supreme Court will grant review.
All right, what I just heard was blah, 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 long time.
Long time.
Blah, 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 long time, will go to the Supreme Court.
Right.
All right. So this could be a couple years before we get a resolution to it.
Yeah, and it increases the pressure on Congress to try to short circuit it by coming up with some kind of arrangement that maybe protects people with pre-existing conditions but dismantles much of the rest of Obamacare. Whether that will happen or not, who knows?
All right, let me ask you to speculate further. One guy on that court made this possible. It's all going to go right back to that one guy in a couple years. Assuming there's no change on the court, he's still going to be the swing on this issue. What makes you think he would vote any differently the second time around?
I don't think he can maintain any credibility at all and vote to retain the mandate. I mean, he issued a very well thought out, very lengthy opinion as to why the mandate is not supported by Congress's commerce power, why it's not supported by the necessary and proper clause.
He being the Texas judge.
Yeah, as long as, if he wants to retain his credibility, he has to agree, I think, that this mandate is unconstitutional.
Roberts.
Whether, on the other hand, it causes a collapse of the entire law, the people arguing against the law can throw his own words at him, because in the opinion, not just that opinion, but also in another opinion written in 2015, he kept emphasizing the centrality of the mandate, how critical it is to the rest of the law. So he might
have boxed himself in.
He may find himself in a box. Exactly the analogy I was going to use.
Fascinating. Robert, as always, check him out at the Independence Institute, independence institute.org. Thank you much. Stay tuned.